Good morning, all. My name is Nick Montague. This is Kelly Turner. We work with Goosmann Law Firm. We run a department called Trust Law Counsel, and the focus of our department is estate planning with folks throughout the Midwest. So this morning, we just wanted to share a little bit of information with you, cover a few quick topics about estate planning, and then let you go on with your day. So the three things we want to cover today are really, we'll talk about wills, we'll talk about powers of attorney, and then we'll also talk about successor guardianships. And that's what Kelly will cover here when we get to that point in just a moment. But really, when we think about estate planning, everybody needs something. We don't all need the same plan. Life is different for everybody. But everybody needs at least a conversation. And really, when we think through estate planning, we always start with our powers of attorney and build up. Okay? Power of attorney is a document that's going to allow somebody to make a decision for you if you're incapacitated. So I'm in surgery because I got in a car accident. Who is that's going to talk to the doctor for me? Who's going to authorize treatment for me? Who's going to pay my medical bills for me? Those are what powers of attorney cover for us. And we typically think about two. We think about financial decisions. We think about medical decisions. And the folks we choose are important. Sometimes that's the same person for each type of situation. Sometimes they're different people based on that individual's ability to make those decisions and your level of trust with that individual as well. And when we think through powers of attorney, the first thing we want to consider is when we want to give somebody authority to make a decision for us. So two types of power of attorney. We think about a springing power of attorney or an immediate power of attorney. So immediate power of attorney is just how it sounds. When I sign the document, the person I have nominated can make decisions for me, whether that be medically or financially, right then. That's one way to look at it. The other one we think about and talk through our springing powers of attorney. So I will nominate someone to make my financial decisions for me, but not until an event has occurred, not until I'm incapacitated because of XYZ reasons, and then the power springs, and then that individual can now make decisions for me. So that's really the first thing we think about is when do I want someone to be able to make a decision for me? Secondarily, we think about who we're going to name, right? Are we going to name one person, multiple people? Who's going to be able to step in there and make decisions for us? We generally see it's a lot of times easier if we have a single individual named as our successor decision maker. Sometimes people love to have two because I've got two kids. I want them both making decisions, and that's fine and it works. From a practical perspective, sometimes that can be difficult, but those are just things to think through. Who is it that I want to make those decisions? And do I want them together or individually to make decisions? And proximity is the other thing we really think through. When we think about medical decisions, sometimes those things happen fast. We need someone there that can come and make decisions for us. So proximity does matter. If I've got someone as a healthcare power of attorney who lives in Beijing, that's going to be tough, right? Live in Florida, that's going to be tough. I'm here in the Midwest. And so it's just something to think through as you establish those type of documents that give someone authority. When do they have authority? Who is it I'm going to give authority? And how close are they? Because sometimes that proximity matters. And so we start with powers of attorney because that's during life. I'm incapacitated. I haven't passed away yet, but something's going on and someone has to do something for me. And from there, we look at wills, right? When I go, how do I get my stuff from A to B? Who do I want to get my assets to? And how do we accomplish that? And that's what the will is. The will is the instruction manual to the court. This is where my stuff goes at the point in time I pass away. And those are really the three main essential estate planning documents we talk about. As a baseline, everybody needs something, right? Everybody needs a document that says, hey, someone can make a decision for me. Everybody needs something that says, hey, when I pass, regardless of what I have, this is where I want it to go. And of course, there's nuances to that in the will, what the will actually controls, how you want to get it to somebody. What if we have minor children? What if we have property in multiple states? What if we have children or folks we care about that have addiction issues, or we're not comfortable with handing them assets at this stage in their life because maybe they haven't demonstrated their ability to manage things. And there's a lot of different issues and concerns and things to think through on that end. What if I have someone I care about, a beneficiary, otherwise receiving government assistance, right? What if they're on a government assistance program? What I pass them, is that going to cause an issue for their qualification? Again, these are all issues we think through and all issues we talk through. But again, as we say estate planning, that's typically where we start. Let's give someone authority. Let's determine how and when they have authority, and let's determine where you want your stuff to go when you pass away. Now, another big issue, big topic we talk through is, and I'll let you talk to it because you talk to it better than I do, but decision makers. Why don't you just take that over? Because I'm not going to.
So you might be in a position where you are the decision maker already for a loved one, or for someone that you've somehow come into contact with, whether you're a guardian or conservator for them. You manage their money, or you take care of their healthcare needs and their living needs and services. Who's going to do that if you're not able to? Whether you have a medical condition that makes you incapacitated, or if you pass away. And traditionally, that's been done in a will. You can ask that somebody else be appointed in your stead, but that's a nomination. That's not something that can take effect until after you pass, and the person will have to go back to court and ask the judge to appoint them. So now you are able to ask for a standby guardian to be appointed, and that's something you would go back and see the court about, and you can have that person qualified and ready to take over that position and that authority should something happen to you. They would just approach the court and let them know either you have passed away or that there has been an event that has disqualified you from serving, and that they are able to take that authority and obtain the letters and an order showing that they have that established with the court, and they are the person who should resume, take over that decision making. And that is a process that is easily done. You just file a petition requesting that the court review the nominee, and that person is going to serve in the instance that you're not able to continue. So then that takes that concern off of your plate and off of your shoulders, and it's not something you have to wait until you pass away to have affected.
Makes it easier. Is that a fair statement?
Yes.
That is the tip of the estate planning iceberg. So again, a lot of nuances. Every situation is a little different. The most important thing about estate planning is having a conversation, being proactive. Unfortunately, more often than not, we see the reactive planning. Something has happened, right? And now we have to react to it. If we can be proactive, if we can get something in place, if we can make decisions now, everybody's in a better off position.